Hello friends, in this video we will see what is a mercy petition, and this topic can be useful for preliminary examination 2022, and my name is J.Sivarajarajendran, and with that information we will go into the video. And some of the key terms that we will see in this video are pardon, commutation, remission, respite and reprieve. So this is what we will see in this video, and the sources that I have taken for making this video is basic Lakshmikant book and the Perarivalan versus State of Tamil Nadu judgment which came yesterday. So and one more judgment is Shatrughan Chauhan versus Union of India judgment. This is the judgment where the Supreme Court Constitutional Bench gave the verdict that inordinate delay in judgments or inordinate delay in disposing mercy petition by governor or the president is may lead to cruelty, and hence the death sentence should be commuted. And this is the judgment which was very instrumental, and there was an UPSC mains question as well based on this. But going into this topic, we'll go first to the topic, or I'll basically tell about the topic which is this case. And this case, everyone might be aware of it. This was the case, or Perarivalan's case is based on the death of our former Prime Minister, and this was a very traumatic event, and this happened on 21st May 1991. And Perarivalan was given as, or was accused number 18, and they registered a case 329 in the place Sri Perumbudur, and this is the place where this bombing happened by LTT associates, and Perarivalan was supposed to be aided this act, and hence he was also registered. And the case was registered on 1991, 21 May 1991, and 21 May is going to come very soon now, 2022. And this judgment happens to be a very significant event now, so that is why we are discussing this judgment. And what we have to know is that when this case was registered, this was done under or there are many acts under which the case, or there was trial going on, but terrorist and disruptive, this is the code, TADA code, Terrorist and Disruptive Activities Prevention Act. Under this court is what this case was held. And the special courts, if you think about it, these courts have special powers, and they are fast track courts, or they can be fast tracked. Normal courts can take a little bit of while. And if you think about it, Sanjay Dutt, he was also arrested due to the possession of arms under this act only. And what happened was, during 1991 the event happened, and 1999 the TADA court sentences the person to death, or the TADA court pronounces the judgment saying that this person who has aided the death of our former Prime Minister has to be, or has to be given death sentence. And what happens after it was, there was a review petition. See, this is the point. All these things you can think about it, and you can just know the basics. When a death sentence is given, there will be a review petition in the High Court. And what happens was, this review petition was dismissed, saying that upholding the death sentence which was passed by the TADA court. And now what happens is that now comes this concept of executive, or the mercy petition by the executive. When the judiciary has dismissed the plea of removing the death sentence, the accused, or the appellant, or Perarivalan, goes to governor under Article 161. So now look at this Article 161. This is what you should know. The power of governor to suspend, remit, commute sentences in certain cases. In certain cases means the laws, or the executive, or the power through which the executive of the state extends. So how much ever the executive power of the state extend and the laws being made in the state, the governor has the moral responsibility for mercy petition under this jurisdiction. And this is one of the very key provisions of the constitution. And you can think, what is the executive power of the state means? The executive power of the state, in a sense, where and all laws. So this is actually article 162. The executive power of the state where it extends means where the legislature can, or the legislature of the state can make laws. So there is a union list, you would have seen there is a union list, state list, concurrent list. And so what and all things under which state can make laws, the executive of the state extends, and hence the governor can or the executive power of the governor extends to that extent. And but can the governor act in his or her own? No, that is not possible, because there is an article, very important article, where it is clearly says, look at this point, it clearly says the governor has to act on the aid and advice of the council of minister with the chief minister as its head. So this has been because, and except for when there is a discretion, and these are special cases in the constitution, but most of the time, even in the Perarivalan judgment case which has come yesterday, the Supreme Court has detailedly gone into this fact of whether aid and advice of the governor has to be considered, or is there any wider discretion for the governor. And the court has said the discretion is limited. Aid and advice of the chief minister is what the governor has to take up in every case. And what happens is that, as see the point, what happens is the Tata court dismisses or the Tata court gives the death sentence, and the High Court or the review petition is dismissed, and the mercy petition to the governor is given. And what happens is that in 2000, so in 2000, the mercy petition is rejected. So the governor rejects the mercy petition, and if you think about it, it is not the rejection of the governor, rather it is an aid and advice of the council of minister. So in 2000, the state government gives an advice for rejecting the mercy petition. And what happens now? So look at this fact now. Under Article 72, so you have extinguished your possibility of review petition in the High Court, and you have extinguished your possibility of mercy petition with the governor. Now you have given a mercy petition for the president. And now you look at this article very clearly, similar to the case of the pardoning power of the governor, the president also has pardoning power, but there is one or few important things that you have to note. In all the cases, see, look at in all the cases of court martial. Court martial means in the armed forces, if there is any punishment, governor cannot come. Only president can come. And in all cases where offenses, this is logical, offenses related to union law, there state law, here union law, and in all cases related to death sentence. And in the Perarivalan case, it was a death sentence, and that is why, so if you think about it, you can so governor or the president has the right of pardon, reprieve, respite, remission, and suspend or commute the sentence with respect to this. And you have to know that this was, see, the point was that the governor rejects the mercy petition in 2000, and the president rejects the mercy petition in 2011. So it's nearly 11 years. And what happens was, this is the point where they filed a petition or the writ petition. So writ petition, if you think about it, it is under Article 32. That is, they are see, what they filed is that this delay, this inordinate delay, this delay which happened for rejection of mercy petition is under Article 21. Article 21, right to life, is a violation of the fundamental right. So that is what the writ petition was filed in the High Court. But this writ petition was taken up by the Honorable Supreme Court. Why the Supreme Court took up this case is that there were a lot of writ petitions filed across India. In case of the delay of these or delay of giving pronouncement to these mercy petitions which were there with the president, and all these writ petitions were taken together in this important Shatru and constitutional bench. And last time there was a question of constitution bench. Important cases related to the constitutional legal terms will be decided by the constitution bench, and this constitution bench of Shatrughan Chauhan is a very important, and this was a mains question as well. So mains question as well, they asked this question. And what happened was, under article, what in this constitutional bench the judges pronounced was, this is an important article: no person shall be deprived of personal liberty, very key. And last time this was liberty under liberal government. How will you protect? So there was a question. So this key term and all from these articles you can take up and you can understand and you can mark in preliminary examination. But no person shall be deprived of personal or life or personal liberty except established law. So that means that if there is a law, so somebody makes a crime and there is a law for punishing that crime, then it's accepted. But if there is no law, means you cannot confine a person's liberty. Here in Shatrughan, and this was actually expanded, this article 21, this ambit has been expanded. What they have expanded is many rights have been expanded into it. And what the Supreme Court said in this is that there is an inordinate delay of mercy petition, or whether the mercy petition should have been rejected or accepted or whatever the case may be. But being in this inordinate delay, this was amounting to a lot of torture, and India is, in a sense, there is an international human rights that we have signed in 1948. So, and there is also international covenant on civil rights, 1960s or somewhere. And hence what the Supreme Court said was, they are commuting the sentence. See, this is the point. They said that because of this inordinate delay, they are commuting the sentence. Now you have to check what is commutation. So pardoning power is different. Commutation is substitute one form. So the death sentence will be or substituted with a lighter form, that is life imprisonment. And this is the point which happened in Shatrughan Chauhan case, where these appellants were given this concept of they were from the death sentence they were given commutation, and Perarivalan was included in that as well. But one more thing next happened is that in criminal procedure code, if you look at this point, in criminal procedure code, the state government has been given the power, section 435. And there is a section 432, 433 clubbed together. All these things clubbed together. If you can think about all these things clubbed together, the state government has the power to remit or give remission or commute the sentence of a person. But in the case of any case which has been investigated by the CBI, so if the case has been investigated by the CBI for the offences under any central act, then the permission of the central government has to be taken. The state government, what it did was, after this commutation, so once the state government got or the Perarivalan got the commutation, the state government made a call that it has been 23 years of imprisonment, so life imprisonment nearly it has happened, and hence they proposed remission, that is a reduction. So see, the point was that the Supreme Court commuted the sentence, but now the state government under section 435 of the criminal procedure code, So they are using their power under this criminal procedure code for invoking remission. But the point you should know is that this case was investigated by the CBI, and hence the central government, see, consultation of with the central government, this has to be done. And once the what happened was this reducing. So what is remission means? Reducing the sentence. So already 23 years have the Perarivalan was in the jail, and hence the center or the state proposed remission or the reduction of the sentence. And once that happens, he could be released. That was the concept. But what center did was not to release. Because this is a case which was investigated by the CBI, the center had to, or the state had to consult the center, and the center said not to release. And what happened immediately was, now again, the appellant went through the article 161 wanted remission. So the initial was the article 161. The appellant went to the governor asking for pardon or the mercy petition. Now the appellant has gone to the governor for remission. So in a sense, what happens now is that this remission was claimed under article 161 to the governor. Now as I earlier said, if the governor has to act, it is by the aid and advice of the cabinet or the council of minister. So there was in 2018 there was a resolution passed. In the assembly for release. So the cabinet pronounced release or the remission of the appellant Mr. Perarivalan. And what happened after this was, the governor did not take action for 2.5 years, nearly 2.5 years. So 2018, look at this, 2018 2021, what the governor did was, he referred the matter to the president. And if you think about it, referring the matter to the president is in the case of bills. In the case of bills passed, Article 200 is accepted. But whether any case under Article 161 for remission of conviction can be passed into the president, and this was a question. And this was the question in Perarivalan's case. What happened? This case went to the Supreme Court and it was going on. But in 2022, bail was granted because of many reasons. The Supreme Court said it has been 31 years, and age, health, education which he has acquired inside, and good conduct, all this resulted in the bail. But what I want you to look at is that last time there was a question on parole. That is, parole is the right of the convict, they said. Right of the convict, no. Parole is the prerogative. That is, it is the prerogative of the. Prerogative means the court can give or not. It is not the right of a person as it is in the case of Article 32, as all the appellants who were not rejected or accepted, the mercy petition were rejected, not accepted. In such inordinate delay, they went to the Supreme Court. That was Article 32. As a right they went, and hence Supreme Court gave this verdict of reducing the sentence of death to commutation of the sentence to life imprisonment. But if you think about it, the other things, so the parole is also one such thing where you cannot ask for as it as a right. And the same way, so this is the judgment which was passed. So because considering, absence of any exceptional or the any other disqualification, and due to the exceptional nature of this case, the appellant under this crime number 329 is set at liberty and at forthwith. Means he was released in the moment yesterday, and he is out now. And this is the so what is that article? So under article they gave this justice under the Article 142. And this was a question in 2019. What is Article 142? Is that the Supreme Court, so look at this, the Supreme Court can exercise its jurisdiction, pass order or decree under any cause. See, any cause or matter pending before it, any cause or matter for, if you think about it, for providing complete justice. So this is the article they used, and hence Pererivalan was released yesterday. And if you think about it, so whether this is correct or not, the politics of this will happen every day. But one person is Pererivalan's mother. She for all these years, in every picture that the TV showed, she was there present. Whether this is, that is the point, whether this is correct or not, both the sides have lost a lot. And that the as Mahatma Gandhi ji used to say, an eye for an eye makes the world blind. I hope both the sides come to terms with violence will not be an end in itself, and violence cannot be a solution for anything. And the violence which happened in Sri Lanka, now we are seeing the consequences of all that. All these years, the country that it is going through a lot of turmoil. But peace be with everyone, and let us thank everyone who has been there part of this. And I hope everyone gets justice in this issue.